My name is Ricardo Martinez, and I'm the Executive Director of Glad Law. I know many of you join us to hear our legal experts break down key legal updates, preview what we can expect this year that could shape the future of LGBTQ rights and impact our communities and answer some pending questions that you may have. And we will get there, but first, I just want to name what many of us may be feeling right now, because pretending that this moment is ordinary would serve um, only the anti-democratic actor strategy um, to exhaust us into numbness. I don't know about y'all, but I'm equally clear-headed and driven to continue doing this work. But I'm also really angry. We're 1 year into this administration that has turned cruelty into policy and impunity into practice. And what we're witnessing isn't simply bad governance, it's misguided priorities. It's a coordinated campaign to terrorize communities, beginning with immigrants and expanding to anyone perceived as another, anyone with the moral clarity to name injustice when they see it. Um, and it's heartbreaking. I think we could just name that it is heartbreaking as we navigate this space. This is passion work for all of us, every single one of us, and everyone who is here that is committed to justice um, and understands the power that the legal system has to uphold civil rights. We know how heartbreaking it is when we see what's happening, not only in Minneapolis, but other countries, other cities like Portland and Washington, D.C. Federal forces deployed without meaningful oversight are conducting raids that separate families, detain people based on appearance, and operate with a lawlessness that should alarm anyone who believes in constitutional limits of power. The people orchestrating this expect our fatigue. They're banking on the idea that facts don't persuade, that institutions can't respond, that we'll eventually stop fighting. But we know something that they don't. The fight isn't new, and neither are we. The legal strategies, the coalitions, the persistence required to push back against authoritarianism, these have been tested and proven across generations of advocacy. So today, our attorneys are going to do two things. Number one, tell you the truth about where we are. And number two, show you the map for where we're going. We're just past the 1 year mark of the second Trump administration. And over that year, we watched an accelerated assault on LGBTQ plus people, particularly transgender people, as well as immigrants, people of color, and the basic civil rights protections that make democracy possible. But we've also seen something else, something pretty beautiful despite the circumstances. And it's the resistance. It's people showing up from individuals, from states, and critically in the courts where precedent and process still create space to fight back. And Glad Law has been among those pushing back, particularly in the courts. And I just want to take a second just to thank all of our staff, all of our board, everyone who has dedicated any time to volunteer in our Glad Law Answers line to help people who are in crisis navigate this space. It takes a lot of emotional bandwidth and labor to do this work, and I'm just incredibly proud of all of our staff, every single one of our constituents who has shown up so incredibly lovingly and supportive during this time, our volunteers and our board. So thank you for doing this work. It is really an honor to do it with you. And I'm going to get started with the first question to Josh. So Josh, can you start with a reminder of some of the legal threats that we've seen and how Glad Law has been responding?
Yeah, for sure. Thanks, Ricardo, and thanks everybody for joining. Um, so I'll briefly touch on the first year of the administration and cover kind of varying sources of the threats that we saw from the federal administration to threats we saw across different states, and then some unfavorable decisions we received from the Supreme Court. Going to be fairly high level. There's going to be a lot here, but my colleagues will be able to go in much more detail on many of these cases. And very big picture, kind of takeaway from the last year, there have been a lot of threats, particularly from the federal administration, and Glad Law has filed 9 different actions against the administration, including the first one on behalf of LGBTQ organizations almost immediately after the administration took office. So if we go back to almost exactly a year ago, the new administration comes in and immediately targets the LGBTQ community, particularly transgender individuals. And it does so via various executive orders, including a trans military ban, an EO related to sports, and what is referred to as the gender ideology EO. And as you all probably know, Gladlaw sued on all three of them. So the first lawsuit against the administration by an LGBTQ advocacy group was brought by Gladlaw against the president's gender ideology executive order, and specifically as that order was being applied to incarcerated transgender women. So we sought in ultimately three different cases to block the Bureau of Prisons from transferring our clients to a men's facility and terminating their medical care. And thanks to the advocacy from my colleagues at Glad Law, we were able to secure preliminary injunctions protecting all of those individuals. We also brought cases on the trans military ban and ultimately received a temporary order stopping the initial implementation of that order. And although that order has since been allowed to go into effect thanks to a Supreme Court shadow docket decision, that case marches on. Our colleagues were just in DC last week arguing for the appeal to sustain the injunction and order that we received. And we're going to continue fighting the trans military ban until it's declared unlawful and wiped from the books. And then finally, we had a case in New Hampshire on behalf of trans female adolescents who just wanted to play sports. And we challenged New Hampshire's law, which prohibited them from doing so. And we ultimately expanded that case in February of last year to challenge the Trump executive order banning transgender girls from participating in school sports. And I know Chris is going to talk about that a little bit later. So that was kind of the initial kind of onslaught that we saw from the administration. But then, throughout 2025, the administration increasingly turned to its use of various the different administrative agencies that it had at its disposal. So Health and Human Services, the Department of Justice, and increasingly used its enforcement apparatus to intimidate healthcare providers and target transgender individuals. And so a number of the cases and matters we worked on throughout 2025 were really focused on pushing back against that effort. So that number one includes motion and case we brought in the District of Maryland, pushing back against an overreaching subpoena, trying to seek out private medical information from trans adolescents who received care at Children's National Hospital. And just very recently, we obtained an order declaring that subpoena unlawful and the government's efforts to investigate to be without any lawful purpose. Similarly, I know Hannah's going to talk a little bit about our TRICARE case, where the government tried to has tried to bar medical care coverage for the trans adolescent dependents of service members. And so we sued on that. We also filed a complaint with the Connecticut Commission on Human Rights and Opportunities on behalf of families whose trans children received health care at Yale New Haven Health and Connecticut Children's Medical Center because those institutions shut down their care prematurely in response to the government's overreaching actions and threats. And so it was important for us, given really strong non-discrimination protections that exist in state law, to stand up for those families. And of course, we have a really robust Know Your Rights and Glad Law Answer component to our work, where a significant, a number of our colleagues just spend a significant amount of time making sure that everyone in the public has the information that they need to be able to vindicate their rights and to be able to separate fact from fiction, particularly given how much is going on in the world. So while all that's happening, there have also been other threats from this administration. There have been continued attacks in education on an LGBTQ plus inclusive policies in schools, and in a really unprecedented use of federal funding to try to coerce local school districts to change their LGBTQ inclusive policies. And so some of the work we've been involved there has been in the background, working with various school districts to make sure that they have what they need to defend their policies. And then also some of it has been very public, such as in Maine, where we filed an amicus brief, again, to defend individuals' private information from overreaching government action. And, when we think about the federal administration from the past year, all of these attacks are related to the administration's general assault on democracy. And, we have not, as an organization, lost sight of the connections between the work that we're doing in the LGBTQ space and broader democratic values and protections. And so, while a lot of that just plays out in the work that I've already talked about, we also, for instance, supported the law firms that were pushing back against unlawful executive orders targeting them for engaging in unfavorable or quote unquote unfavorable pro bono service. And we also submitted comments in response to the Department of Education's efforts to use student loan debt to coerce nonprofit institutions to fold to the will of the administration. Unfortunately, the federal attacks have not been all that we saw over the last year. A lot has also been happening at the state level. Similarly, around issues around sports, bathroom access, and education. And so there too, we have, number one, been working really hard to increase protections in justice zones, including in here in Massachusetts, where we've been able to pass laws to expand protections for LGBTQ individuals. In Maine, we defeated all 8 with our coalition partners anti-trans laws that were put up in that state. And we filed with coalition partners in New Hampshire a lawsuit against their efforts to bar DEI curriculum in their schools. Last thing I'll say here before turning it back to Ricardo, which I would just be remiss if I didn't mention, is again, we have the federal attacks, we have the state attacks, and then we also saw some unfavorable decisions from the Supreme Court, including Mahmoud versus Taylor, which involved religious objections to certain LGBTQ books in schools, and the Supreme Court ultimately allowing certain opt-outs to that curriculum. And then United States versus Skermeti involving the Supreme Court upholding a Tennessee law barring trans healthcare for adolescents. And while those decisions in many ways were heartbreaking and setbacks, we also have done a lot of work, number one, to make clear to those who need to know and to the public the limits of those decisions, because, oftentimes there's a risk of overreading what the Supreme Court says, and it's important that we, draw a line in the sand of what those decisions actually mean. And then two, it's, continue to force us to be creative and strategic in evaluating what potential claims are available as we look to the years ahead.
That is a lot, but thank you for the recap. It's been quite a year, and that is not fully a full accounting of every single thing that our team has done. So, but it is a good overview. Thank you, Josh. I'm going to turn it over to Michael now. One of the first cases that Glad Law filed was a challenge to the transgender military ban. Michael, what's at stake in that case, and why is it so important to bring it?
Yeah, thanks, Ricardo. So, like Josh mentioned, one of the first actions that the Trump administration took was to issue an executive order to bar transgender service members from serving in the military. And Gladlaw filed a challenge to that executive order the day after it was issued. And that order is one thing that's just very striking is how hostile it is on its face to transgender service members. There's no hiding what they're trying to do here. It says that being transgender conflicts with a service member's commitment to an honorable, truthful, and disciplined lifestyle, and that being transgender is not consistent with the humility and selflessness required of a service member. Like these are just statements that go beyond the typical type of more veiled attacks that we've seen before. This is just straight up discrimination. So we filed a case, and over the course of the first few months, we gradually found more and more people who were affected, and ultimately are representing 30 current and prospective members of the armed forces across all branches. So Army, Navy, Marines, Air Force, Space Force. And they have exemplary service records. Between them, they have over 260 years of combined service. They have earned more than 120 commendations. They've deployed around the globe to on battle carriers into Afghanistan and Iraq, and domestically doing all kinds of really important things. And they have continued to meet standards right up until they were this EO came about. In some cases, some of them have not even ever taken a sick day. Um, And just to put this case in context, I just want to read a little bit from as Josh mentioned, we got an order from our district court, the first court that we went to, temporarily blocking the ban. And to put this case in kind of a larger context, there's a passage in that order that I find especially poignant, that I want to read for you all. So our judge wrote, "The president has the power, indeed the obligation, to ensure military readiness. At times, however, leaders have used concern for military readiness to deny marginalized persons the privilege of serving. Fill in the blank is not fully capable and will hinder combat effectiveness. Fill in the blank will disrupt unit cohesion and so diminish military effectiveness. Allowing fill in the blank to serve will undermine training, make it impossible to recruit successfully, and disrupt military order. First minorities, then women in combat, then gays filled that blank. Today, however, our military is stronger and our nation is safer for the millions of such blanks and all other persons who serve." So the military has historically been just an engine of economic mobility, offering educational and career opportunities. It has also been really influential in number of civil rights advances. So, for example, racial integration of the armed forces led a lot of people to encounter people of other backgrounds who they ordinarily would not have encountered, and that is credited with increasing support for the civil rights movement earlier in the 20th century. So, similarly today, a known hurdle that we face for the fight for transgender rights is that many people say that they don't know a transgender person, but most people know the military. They understand how demanding it is. They acknowledge that it's important to respect people who have met those standards and risked their lives for our country. And that just really underscores how important this case is, on top of just being a strong, like, important advocacy for our clients, and to ensure that they're able to continue to serve in the way they have for many years.
Thanks, Michael. It just occurred to me that we may have some of our plaintiffs joining us tonight. So if they happen to be joining us, thank you for your service and your courage. We appreciate you very much. Michael, you were just in DC at the Court of Appeals last week with some of our plaintiffs. Can you tell us about the argument and where things stand?
Yeah. So as Josh mentioned, we did get an order early on in our case back in March that blocked the ban temporarily. The Supreme Court issued a shadow docket ruling in a different case that has allowed the ban to go into effect. And we were before a three-judge panel at the Court of Appeals in DC, and those judges are going to decide whether our order was correct to ban to stop the ban. Um, and there are a couple of things that are different about our case than about the other case, that the shadow docket case. And one of the really important ones is this idea of animus. And there's important legal rules that say that the government cannot take some kind of action against a group of people simply because it doesn't like them. And as I read to you some of the phrasing in that order, it's very clear that what the government is doing here is they are taking action because they don't like transgender people, and that violates the Constitution. The judge in the other case reached the same conclusion for different reasons, but he did not address this whole animus issue. So that's one very important reason why our case is different, and the outcome of this argument really matters. The arguments lasted for over 3 hours, which is unusually long. We were scheduled for 10 to 15 minutes per side and went for an hour and a half per side. And that really shows that the judges are taking this extremely seriously. There was a lot of really thoughtful questions. You could tell that they acknowledged and respected the service that our plaintiffs have provided. Um, and they seem to recognize the huge role that animus is playing in the government's actions here. And they are also really wrestling with how to interpret this shadow docket ruling that the Supreme Court issued without any reasoning. They have to, like, judges have to follow what the Supreme Court tells them to do. And they are trying to figure out how to do that without any real guidance from the Supreme Court. And there are a lot of ways that this could go, that we could have the preliminary injunction upheld in part or not at all. They could send part of it down to the district court for further proceedings. And we expect it's going to be a couple of months at least before we know the outcome of it. But all that doesn't detract from the fact that Shannon Minter from National Center for LGBTQ Rights, who argued the case as co-counsel with us, just did an incredible job of laying out how important it is that these plaintiffs who have served remarkably and want to continue to serve in spite of everything the government is throwing at them should be allowed to continue to serve.
But folks who are interested, I'm sure that there is online an audio recording of that argument. So I was there. It was 3 hours. It was surprising that it went that long, but I agree. I think there were really thoughtful questions that were being asked and really robust discussion. Um, and I ended up having kind of a new appreciation for the work that just goes into preparing for kind of the unknown. To stand up there for an hour and a half like Shannon did was really just incredible to witness. Can you talk about what's happened to service members since SCOTUS let the ban take effect?
Yeah, so the plaintiffs in our case have just had their whole lives completely upended. Many of them have served for decades. They have their entire professional careers have been in the military, and they have had that completely like stripped away from them. And the thoughtless way that the ban was implemented has really highlighted its cruelty. So we had a plaintiff who was pulled from an active combat zone where she was serving as the only medic. We had a plaintiff who was at a hospital awaiting surgery and had herself pulled out of the OR when the ban went into effect. So there was the fact that there was really no planning. This was just a immediate and animus riddled effort to pull transgender people out of the military as quickly as possible is just so evident from how thoughtlessly it was implemented. They all stand to lose their careers, their pay, their benefits, and these are all things that they have earned through years of service. And another item that sort of highlights just how cruel this all is a second as a I guess a third case that we brought that's related to the military ban. So last summer, the military offered transgender service members in the Air Force specifically, who had between 15 and 17 years of service, the opportunity to retire rather than going through an involuntary separation process. And several transgender members applied, and the Air Force granted their applications and issued retirement orders. So these are folks who had, in hand pieces of paper that said you can retire, you can get benefits. Um, and then a couple of weeks later, the Air Force rescinded those retirement orders and they provided no explanation for why they were doing that. And instead, they're going to force these members to go through this involuntary separation process. So we brought a lawsuit on behalf of 17 Air Force members who received those orders and then had them rescinded. Those orders would have entitled them to pensions and to medical benefits. And those are all things that we guarantee to troops in recognition of the sacrifices that they make. Pensions in particular recognize that there are a lot of constraints on military service that make saving for retirement really hard for people who are in service, much harder than it is in the private sector. They forego more lucrative private sector careers. They have frequent moves that makes them harder for them to build things like home equity, can make it really difficult for their spouses to build careers. And so our plaintiffs really earned that retirement. It was a promise that was made to them, and the government broke its promise. So we're doing everything we can to make sure that the government makes good on that promise.
Thanks, Michael. Before we leave the military context, I want to talk about what's happening to military families who have transgender kids. We know this administration is showing complete hostility towards trans kids and families, and one especially cruel way that they're doing this is trying to block access to healthcare. Hannah, what's happening in the military when it comes to healthcare?
Sure. So many military families, including the children of service members, rely on TRICARE for their health insurance. And for nearly a decade, TRICARE covered for these young people medically necessary medications like hormones and puberty blockers. Additionally, for the last several years, many folks were able to access the healthcare services they need directly at military treatment facilities. That changed last year, just a few months into the new administration last spring. The Department of Defense took action to cut off TRICARE coverage for military families and to force military doctors to abandon their patients. This was immensely distressing for families of transgender folks who had placed tremendous trust in their military doctors. They now had to search for new doctors at a time when access to trans healthcare, particularly for young people, across the country was becoming ever more uncertain. And so, as Josh mentioned earlier, GLAD Law and our partners filed a lawsuit on behalf of Brave families who've been impacted by these harmful policies. Specifically, what we are arguing is that the department's new policies violate the Administrative Procedure Act. So, in other words, we're saying that the department didn't follow the required procedures when they issued these policies, and that the policies were inconsistent with the National Defense Authorization Act passed by Congress. We're also arguing that the policies violate really the foundational principle of separation of powers, because the Trump administration, the executive branch, is effectively trying to amend a law passed by Congress to make it say something that it just doesn't. And finally, we're saying that their actions were arbitrary and capricious, meaning they didn't explain their reasoning, they didn't cite evidence, and they didn't consider the robust evidence base that exists supporting this care as effective and as safe.
And this is in the context of broader attacks on care. We've seen the administration try to intimidate providers and families by subpoenaing private health information and threatening to withhold funding from hospitals that provide care. Can you talk about what the administration is doing, where that stands, and what kind of pushback we are seeing?
Yeah, well, I'll start by saying, absolutely we are seeing pushback. We're seeing a lot of pushback, and that's a good thing. So none of the administration's threats are able to be enforced at this time. That's really important for providers to know, it's important for hospitals to know, and it's important for families to know. In terms of what's happening, I'll start by talking about some of the subpoenas that have been issued in the healthcare context. So last summer, the Department of Justice sent more than 20 subpoenas to hospitals and healthcare providers that had been offering medically necessary care to transgender young people. The DOJ claimed these subpoenas were to investigate alleged federal healthcare offenses. What they were actually doing was going on a fishing expedition to harass and intimidate healthcare providers. Of course, these subpoenas were extraordinarily frightening for families. They sought a broad array of information, including the identifying information of minor patients, and private medical information, sensitive medical information. So it goes without saying, this is a huge privacy violation that we're talking about. Many of the hospitals that received these subpoenas moved to quash them, which basically means that they've asked courts to find that the subpoenas are invalid and that the hospitals don't have to respond. Some hospitals haven't moved to quash, and in some of those cases, there's been a need for others to step in. Given the privacy interests of youth and of parents, of families that are at stake, we felt the voices of families were a critical part in pushing back against these subpoenas. So GLADlaw filed a motion in November on behalf of 8 families asking a federal court in Maryland to quash the subpoena that had been sent to Children's National Hospital in DC. And as Josh alluded, just last week, the court decided that that subpoena lacked a proper investigative purpose and that it was a pretext for the Trump administration's agenda to end healthcare for all trans people, particularly young people. The court also recognized that there were really important privacy interests at stake. And I think that's a key and promising development, not only for this case, but also for all people who don't want the government rifling through their private medical records. And this isn't the only win in this context. Lawyers across the country have been making similar arguments. And so far, courts have been saying, you know what? Hey, actually, the DOJ can't do this. And so that's a piece of good news to share. Of course, the subpoenas are not the only way that the administration is trying to shut down care for trans people, again, especially young people. And so, unfortunately, there are some healthcare institutions that actually have stopped providing care, which is, I would say, a really troubling pattern of preemptive compliance with threats that have yet to materialize.
And GLADlaw is challenging these.
Yeah, absolutely. We're working to defend the healthcare landscape from federal attacks. And it's also an important moment for states and for private institutions to stand with the trans community and to stand up for healthcare generally. So, to that end, we have sued 2 hospitals in Connecticut that abruptly announced last summer that they were ending medically necessary treatment for trans youth. Those hospitals are continuing to offer hormones and puberty blockers to patients who aren't transgender. These changes were absolutely devastating to patients and to their families. Our clients have had to deal with all manner of disruptions, ranging from delayed treatment decisions to 9-hour trips to see new doctors. And not all of our patients even have been able to identify yet new doctors. In addition to these sort of tangible impacts, this has caused an enormous breach of trust for our clients in the healthcare system. In some cases, they had spent years carefully building relationships with their doctors and finding a treatment plan that worked for their child. And then they had all of that really ripped away from them pretty much overnight. One thing that I think is really critical here is that even though the federal government has certainly been attacking healthcare for trans folks, there was no law in place and there was no policy in place requiring that these hospitals stop caring for their patients. To the contrary, Connecticut state law prohibits discrimination in hospitals on the basis of sex or on gender identity. So we filed complaints arguing that the hospitals violated these state laws.
What other major developments are we seeing around healthcare?
Well, in December, the administration announced multiple new proposed policies and issued some other just really awful materials, continuing their attack on trans healthcare. So first, the Department of Health and Human Services, led by RFK, issued a declaration essentially saying that the department doesn't care what the science says. It's doubling down on false views about the safety of this healthcare, despite all of the evidence showing that this healthcare is safe and that it is effective. And the declaration essentially is purporting to enable HHS to exclude healthcare providers who care for trans youth from participating in Medicare and Medicaid. In response to that, 22 states sued, and HHS has agreed not to exclude any providers from Medicare and Medicaid programs for now, at least into the spring. So there's a pause on implementation there. The Department of Health and Human Services also proposed two new rules, and folks have probably seen these in the news or in other places, but I'll explain them briefly. The first would directly impact Medicaid and CHIP, which of course are two programs that are enormously important for the healthcare of young people. And so this first rule would prevent state Medicaid programs from covering the treatments that trans youth need to be healthy. The second proposed rule is what's known as the Conditions of Participation Rule. If this rule were to go into effect, hospitals that receive Medicaid or Medicare funds would be prohibited from providing medically necessary treatment for gender dysphoria to patients under 18. A couple of things that I want to note about these new developments. First, none of these actions would make this healthcare illegal. And so I think that's important to remember. Second, neither of these two rules has gone into effect yet, and they might not. We certainly anticipate that there will be legal challenges filed if these rules are finalized.
We have a question that kind of aligns with the next question I was going to ask you, Hannah. So I'm going to try to merge them. Someone in the chat wants to know if there's anything that allies in Connecticut can do to help with the CHRO hospital cases. And generally, number one, I want to express gratitude to everything that you and the rest of our GLAD Law attorneys are doing and other legal partners are doing across multiple states fighting back. Are there things that people can do individually as well?
Yeah, absolutely. So I can speak about this in terms of kind of the broader healthcare landscape, which I think is applicable to more local situations in cases like the CHRO case. First, I want to say that anyone can submit a comment on the proposed rules that are coming out of HHS. So we'll put a link in the chat to a portal that explains how folks can submit comments in ways that protect your family's privacy. And I want to be clear, like you don't have to think that submitting a comment is going to prevent these rules from ever being issued in order to think that it's worthwhile. The goal here really is to get in as many comments as possible, as many individualized comments as possible, and make sure that the administration has a lot of feedback that it needs to review, and to try to slow and mitigate harm that might come. The other thing that I would encourage folks to do is to talk to healthcare providers in your community, talk to youth and families in your community, and see how you can support advocacy that's happening on the ground in your city, at your state, in state legislature, and also to tap into mutual aid efforts, which I think are such an incredibly important resource at this time when so much is changing for families so fast. And then the third thing I want to say is please do contact GLAD Law Answers. You can reach out to us for information that's relevant to your family or maybe to your workplace. But you can also reach out to share with us information about how you see these attacks on healthcare that are coming down, playing out near you in your community, in your life. And I know we probably need to move on to other topics, but I guess I'll just say, I do think that pushing back on these attacks is so critical, not only for trans youth and families, but also for the integrity of our healthcare system in general. We are seeing in everything from the administration's undermining of vaccines to its attempts to use Medicaid data against immigrant communities to these recent attacks on trans youth. Um, that really they are going after medical science, they're going after medical institutions, they're going after patients, and they're going after healthcare itself. And so I think this is a systemic issue. It's something that impacts all of us, and it's one that requires all of us to respond with urgency, however we can.
Thank you very much, Hannah. In addition to healthcare, the administration is also targeting transgender kids in education. And that's something that has been building for a number of years in states, particularly when it comes to participation in sports. I'm sure most people know there was a significant argument at the Supreme Court. Chris, what is the Supreme Court deciding in this case?
Well, for more than 2 decades across the country, transgender young people and their families have been advocating for accommodations in public schools, including in school sports, right alongside other areas like dress codes, access to bathrooms, names and pronouns, and protections from bullying and harassment. And advocates and school policy experts have had a shared understanding that public schools have an obligation to educate all students, including transgender and gender nonconforming students, and that if trans kids are wholesale excluded from any area of their education, then they're not getting what they need to thrive. Sports is a foundational part of school life for every student, even for students who choose not to participate in sports. It's a part of the culture of schools, and it's an essential part of what education means in this country. And over time, individual accommodations have given rise to statewide athletic policies that have attempted to balance goals of ensuring opportunity for all students with concerns about competitive fairness, about risk of injury. And these policies have been working. But about 6 or 7 years ago, cynical politicians started a new campaign of fear mongering around transgender girls on girls' sports teams, making people believe that there was this huge national crisis, and that led to statewide bans. Idaho was the first state, and many other states followed. Now, about half the states in the country have bans that prohibit transgender girls from playing on girls' school sports teams. And many of these bans are in states that have only one or two transgender girls who had been playing sports, or even none at all in some cases. In many states, the transgender girls impacted by these bans are students who do not have any athletic advantage at all over any other girls. So organizations like GLAD Law, the National Center for LGBTQ Rights, the ACLU, Lambda Legal, brought lawsuits in some of these states on behalf of impacted students, challenging these bans as unlawful discrimination. And these lawsuits almost universally have resulted in good outcomes because courts could see very clearly that there's no basis to exclude these girls from playing sports with their friends. And the only real motivation behind these state laws were general disapproval of trans students and fear about what people didn't really understand. So last year, the Supreme Court decided to reconsider what these courts have said about discrimination against transgender students. They did that by taking up two cases, Little versus Hecox out of Idaho and West Virginia versus BPJ. Taking these cases was kind of shocking for a couple of reasons. First of all, these lawsuits only impacted a very small number of students nationwide. The Supreme Court does not take very many cases, and it's very unusual to take up cases that impact such a small number of people. Also, there really wasn't any dispute among courts. Most of the time, the Supreme Court gets involved in issues like this only when courts are in disagreement about the law. So it's very unusual that the Supreme Court would address the rights of transgender girls to play school sports. Also, the plaintiff in the Idaho case had asked that her case get dropped. She has been dealing with this lawsuit for years. She's trying to finish college and she's not even playing sports anymore. But so far, the Supreme Court has forced her to continue on as a plaintiff in the case. Anyway, the parties have filed their briefs and recently had oral arguments before the Supreme Court. We will almost certainly get a decision by the end of June at the latest. And the stakes are actually higher than you might think. Um, when the plaintiffs argued that it's discrimination to exclude them from school sports, one of their primary arguments is that Title IX guarantees that transgender students have the right to equal educational opportunities free from discrimination. If the Supreme Court disagrees with that, that could have a huge impact on how courts look at sex discrimination in schools. That could change a lot about how we think about protections for LGBTQ students in our public schools all across the country. And the other major legal issue is whether the US Constitution protects transgender people from discrimination by government entities like our public schools. The Supreme Court hasn't squarely faced the question of whether our Constitution's protections against sex discrimination also protect LGBTQ people generally. That's something the Supreme Court might be ruling on in these cases, and that could have a really resounding impact as well.
I'm going to go a little out of order with this next question because I think it's most relevant to what you were just talking about, Chris. You listened to the Supreme Court argument. What can you say about how it went?
That's a really good question. Um, so uh, I had some interesting insights when I was looking at what the court was saying, but I do want to like make the point that it's really impossible to predict what the court's going to decide just based on the conversations at oral arguments. But I do have a few observations that I can share. First, Justice Sotomayor did a really great job highlighting the humanity of how this case impacts Lindsay Hecox, the plaintiff in the Idaho case who has to be let off the hook. She put a name to the hardship that these kids have to endure to fight for their rights. And that's something that we're all too familiar with because of the kids and families we've been working with. The justices are really all over the place on important questions about how to think about constitutional claims by a small number of individuals when it comes to challenging big state laws. I cannot tell you anything about where they're headed on the constitutional questions. But the biggest insights I have are coming from the discussion of Title IX. It was really clear to me that the justices do not have any interest in making a broad ruling that's going to exclude all transgender girls from all school sports nationwide. That was a possibility, but the justices were pretty clear that they're not looking at these cases as an opportunity to make a ruling that would, say, impact students in a state like Massachusetts, where transgender students are not banned from school sports. Furthermore, the justices were searching for extremely narrow ways to think about Title IX. For example, they asked a lot of questions about the Javits Amendment, which is a piece of Title IX that authorizes reasonable regulation around sports. So there's reason to hope that they will look for a way to decide this case narrowly, which might help prevent a really bad outcome from having an outsized impact far beyond just sports.
Thanks, Chris. Just returning to Glad Law's work, we represented or are representing two transgender high school girls in a different case challenging a New Hampshire ban. And we also filed it from the court brief at the Supreme Court. What do you think is important for people and the courts to understand about this?
Yeah, so many of you might remember back in the summer of 2024 when our client Parker Terrell was photographed outside the courthouse in New Hampshire. She was all dressed for soccer practice because she literally had to go to court on the day that soccer practice started so that we could ask a judge for an order saying she could play and participate with her friends. Fortunately, the judge ruled in her favor that day with a temporary order and she was allowed to play. Later, that order was extended to cover both Parker and our other client, Iris, while the litigation continues on. And I want to share this quote from Parker. All my teammates, my friends, everyone was always right with me saying, we want to play soccer with you. We want you to be safe, and we think you deserve this too. And fortunately, she was able to play with her team all throughout her sophomore year. Meanwhile, a group of parents showed up at one of Parker's games at another school in order to protest her. The school officials sent a couple of those parents away, and then those parents ended up filing a separate lawsuit saying that their First Amendment rights were violated. They argue that they should have the right to show up at school events just to harass a teenager. I'm telling you this to give you a sense of how ridiculous it is that a teenage girl who just wants to play soccer with her friends has to deal with this huge spotlight and circus around her. And just about a year ago, something else terrible happened. The president issued a new executive order, as you heard, trying to ban all transgender girls from playing on girls' sports teams nationwide. And of course, that order impacts our clients too. So we went back to the judge and asked to expand our lawsuit to also challenge the executive order. The judge agreed. And then when the Supreme Court said they would take up the Idaho and West Virginia cases, the judge put our case on pause until that is all decided. To this day, Parker and Iris still have the right to play. GLAD has been working on this issue for well over a decade, and we have a lot of insight into how schools can ensure that trans students get all the benefits of public education while still ensuring that sports can be fair and safe for everyone. So we partnered with NCLR to write an amicus brief to the Supreme Court, highlighting for the justices the key lessons that we have learned. Specifically, we explained that many states have figured out policies that do not ban transgender students from school sports, but also take into consideration difficult questions about fairness and safety. The hallmark of these policies is individualized assessment, meaning that eligibility should be determined on a case-by-case basis, and the default in all situations should be inclusion. That's what the law requires, and that has also been backed up by the science. I just want to make one more note. Next week on February 5th, GLAD is joining the ACLU of Massachusetts for a virtual event where we will be discussing BPJ and HECOX more in depth. So please sign up and attend if you are interested in hearing more.
Thanks, Chris. One more question. Transgender kids' ability to participate in sports at school is being used as a political wedge issue. And this question about whether trans kids and really all kids get to feel like they belong is just one part of what's happening in schools. What else is going on when it comes to education?
Gosh, that's a really good question. We're seeing so much happening in our schools, in state legislatures, and in courts, and especially in school committees and school boards. Perennial issues like access to bathrooms, appropriate pronouns, those are still being debated everywhere. We are still fighting about censorship of LGBTQ people, LGBTQ history, and LGBTQ themes in our schools, particularly those objections grounded in religious objections, since the Supreme Court decided Mahmoud last year, which Josh mentioned earlier. The Supreme Court has a couple of cases that it may or may not take up regarding forced outing, because some legal groups have pushed forward cases arguing that the Constitution requires schools to tell parents if they suspect that their kids are LGBTQ. So those are just some of the things we're facing right now.
Thank you, Chris. And what can folks do?
Well, I always have the same answer to this question. The biggest impact that most people can have starts with their local school communities. School committees and school boards are some of our most democratic institutions. We can make a huge impact just by showing up at meetings when issues impacting LGBTQ students are being discussed. I have seen countless times what a big difference we can all make when we are watching and participating on that level. You don't need to have kids in school to have a say in what happens in our school districts. The biggest challenge is always knowing when something is going on in the first place. So I really do encourage all of you to plug into your community's school groups so that you can be aware when school board agendas raise issues that affect LGBTQ kids and their families.
Thanks, Chris. I want to wrap up with Josh. And my question to you is going to be about what's on the horizon for the second year in Trump 2.0 and what we can all do moving forward. But since we've covered so much and so much of it is just heavy, if you could sprinkle some like good news or some wins that we've had throughout the last year to give people hope that despite kind of the circumstance that we are in, where we are forced to be in a defensive posture, there are still some wonderful things that we are doing on the offensive side to really think thoughtfully about creating change where we have the ability to do so. So I'm going to turn it to you, Josh. What's on the horizon? Tell us a little bit about some of the wins.
Yeah, for sure. I'm happy to kind of preview the year ahead. And I think just to underscore, it's, the team is obviously doing a tremendous amount of work, and it's also just a lot that we're all kind of living through in the moment. But as Ricardo is alluding to, there are some bright spots from 2025 and some bright spots that we have on the horizon in 2026. And I will say, just for me personally, despite all of what we're witnessing right now, I remain optimistic, not only for the LGBTQ community and our rights, but for the preservation of our democracy more generally. So I'll start by talking about, some likely decisions from the Supreme Court that we'll see in 2026. And I think the most notable one that hasn't come up thus far relates to a challenge to Colorado's ban on conversion therapy practices. And so the Supreme Court heard oral argument on that case in October, and we anticipate a decision by the summer. So Glad Law, we filed a brief on behalf of survivors of conversion therapy practices who underscored not only how conversion therapy practices impacted their own life and harmed them, but how it really splintered their family relationships and their relationships with their faith communities. And that, so, regardless of where the Supreme Court ultimately comes out in that case, number one, I think the work that we did there and the work of some of our partners just brought additional voices to the discussion about some of these issues and the connections to, for instance, faith communities that aren't typically focused on. And, setting that out in a brief and kind of uplifting that narrative has kind of a longer term effects that we can kind of move on regardless of where the court comes out. And then number two, regardless of where the court comes out, the movement more generally across the country is already thinking through what options might look like if we get an unfavorable decision. I will say when it comes to the Supreme Court more generally, because, I get a lot of questions about shadow docket decisions and how could the Supreme Court allow this or that. One thing I would consider a bright spot is the Supreme Court only hears so many cases per year. And when you take a look at, the data, particularly around the challenges to Trump administration policies, it's actually a really small number that's actually making its way up to the Supreme Court. And so when you look at the total number of challenges that have been brought against the administration, which I think is upwards of 500 at this point, in the vast majority of them, the plaintiffs are winning, and courts at the district court level and then the intermediate appellate courts are holding the administration accountable for their unlawful actions. And so one of the things I am really focused on, and I know the team is really focused on in 2026, is not losing sight of that even though we might get some unfavorable decisions from the Supreme Court and have gotten some unfavorable decisions, that's really just one piece of the puzzle when it comes to litigation in the courts. 2026 will undoubtedly as well bring, continued attacks from the federal administration that we're gearing up to respond to, including some of them that, Hannah talked about earlier related to healthcare, some related to housing protections for all LGBTQ individuals, and a continued use of federal funding to target HIV prevention and treatment, target school districts, and in Congress as well, efforts to try to add anti-LGBTQ riders to their appropriation bills. Again, though, in 2025, while we and our partners across the country didn't win everything, there was a heck of a lot that was stopped by advocates across the country, number one. And then, to get really specific there, when we think about Congress, as of right now, as Congress moves forward in finalizing some of its appropriation bills for the coming year to fund the government, all of the anti-LGBTQ riders have been stripped from those pieces of legislation. Looking ahead to the rest of this year, there's also, I think, some bright spots as it relates to our family law work, including our marriage defense work. So I think in 2025, we saw Kim Davis of longtime fame now tried to bring a case challenging marriage equality up to the Supreme Court. And I think as folks know, we at Glad Law have been working to defend marriage equality since Obergefell was decided and have had a dedicated team focused on defending marriage equality for the past few years. And so in the lead up to that, this team was doing a lot of work with partners across the country to convince the Supreme Court that that case, number one, was not a vehicle worth considering, and that number two, marriage equality has been good for families, good for businesses, good for communities, good for the country. And ultimately, the Supreme Court very quickly declined to take up that case for review. Certainly, our opponents are going to continue to take aim at marriage equality, but we're taking action to make sure that we're several steps ahead of them so that we don't give an inch there. Similarly, there's been a lot of work that our team, particularly Polly Crozier, our Director of Family Advocacy, has done as it relates to protecting family recognition in states across the country. So just, by way of example, in 2025, we saw the Massachusetts Parentage Act go into effect, and we passed similar laws in other states, including Illinois. And in 2026, Polly and others on the team are already doing a lot of work to expand those protections in states where there are opportunities to pass similar laws, and also to pass laws that expand access to reproductive care, including fertility care. As we think about New England going into 2026 and the years ahead, one of our key strategic pillars is to ensure that New England remains a justice zone, both for the protections within New England, but also so longer term when we have a different federal administration and are out of this, there are states that can show the rest of the country a model for how a pluralistic, multicultural democracy can operate. And so there are a lot of opportunities that we're pushing forward in New England states as of right now, including here in Massachusetts, where our attorneys, including one of our senior directors, Ben Klein, is pushing for a bill that would ensure affordable access to injectable PrEP here in the state. So, while there's certainly some kind of defensive work that we have to do in states like Maine and New Hampshire, in states like Massachusetts, Connecticut, Vermont, there's a lot of work we're doing to expand non-discrimination protections and expand the protections that exist for the LGBTQ community. And then, the final piece I'll end on here is just on kind of the democracy preservation question that I ended my kind of remarks to the first question on, because I think it's hard not to be in this moment and question how, as a democracy, like how we're going to get through this as a democracy. And it can certainly feel bleak at times. And there are a lot of people standing up collectively to fight back in ways that are working, and that I remain more convinced than ever will continue to work. So again, by way of example, that includes the law firms that did not capitulate to the administration, like Jenner and Block and Perkins Coie, who won really strong orders from the trial court declaring the administration's targeting of them unlawful. Will now be defending that on appeal, and there'll be opportunities for organizations like ours to get involved to assist through amicus efforts to defend those decisions. And then more generally, the solidarity that currently exists just across the nonprofit network, both locally and across the entire country, has been tremendous. I think there was an article from, I think, October, where a group of 500 plus nonprofits, which includes GLAD Law, signed on to collective solidarity and collective action, calling, I think Vanita Gupta called it the NATO for nonprofits. And standing up in that collective way has not only mattered thus far in how we're seeing different organizations respond to the federal government's overreach and threats, but is going to be critical for the years to come. And again, I just remain convinced that will help us prevail at the end of all of this.
Thank you, Josh. I know that we're a couple of minutes over. Just 30 seconds left before we call it. I just want to say thank you for all of you for showing up. Thank you to our staff. Thank you to our board. Thank you to all of our volunteers and our donors. GLAD Law is going to continue doing what we do. We're going to keep showing up and doing everything that we can in the courts and state legislatures to stop, delay, and reduce the harm inflicted upon LGBTQ plus people and on civil rights for all of us. And there are things that we can all do to protect our families and stay engaged in working for the world that we want to see. I, similarly to you, Josh, believe that, the United States can rise and fulfill its democratic potential, and it's going to take all of us to do that. Thank you for being here tonight and for staying informed in moments like these. Community connection and knowledge are some of the most powerful tools. If you have questions about your specific situation or want to learn a little bit more about how to get involved with GLAD Law's work, please visit our website at gladlaw.org. There's a lot of links that were dropped into the chat, but just another plug for if you have a specific question to you, a legal question, you can contact GLAD Law Answers. And it's pretty easy to navigate once you get to our website. Have conversations, engage in school boards, make sure that you participate in that HHS comment portal link, register to vote, make sure others do the same, and keep hope. I think it is a discipline. I think it is important that we do so. And just as we can, in practice, see all the bad, I think it's also equally important for us to just look around all the good that still does remain. So thank you very much for everyone's participation tonight. Thank you to Michael, to Joshua, to Chris, to Hannah. Appreciate you all very much. And thanks to the communications and public education folks who helped put this together. Appreciate you all so much and have a good night.